The broadcast is now starting. All attendees are in listen-only mode.
Hello, and thank you for tuning in. My name is Brad Micklin. We're going to start this webinar in just a second. Okay, so real quick, if you're signing on, welcome. Thank you for coming and tuning in. A couple housekeeping things before we jump into the material. First, you should have a control panel on your screen that allows you to leave notes and ask questions. So if somebody or any of you can go in and type into the chat portion just to make sure that you are able to hear me, because my microphone seems to be working, but I always want to make sure. And with that, we're going to jump into the information and today's webinar from the Micklin Law Group's monthly webinar series, Emergency Custody. Those that have not worked with me before, this is me. My name is Brad Micklin. I am the managing member and lead attorney of the Micklin Law Group. We are a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters. And we have offices in Nutley, Montclair, and Saddlebrook, New Jersey. The slide that's on the screen has a QR code. I have to say I haven't checked it, but I believe that allows you to go to my online calendar if you need to schedule a consultation. If you're not a client, you should be able to do that, and then my office will follow up to do a brief intake. If you are a client, obviously you can also use that to get on my calendar, as well as the link that you will find in all of my email signatures. Here are some awards I've received in the past, thanks to the gracious support of my clients and colleagues. I don't put these up to impress you, but to impress upon you that I have been doing this a long time. I am well versed in the areas that I cover, and because we have what I call a micro niche of men's and fathers' rights, we handle very few issues, very few types of cases, so I believe and hope that we handle them exceptionally well. I've also been called upon as a legal consultant, various legal matters, Fox News, Inside Edition, Larry King when he was with us, great guy, I-24 News, and many others. Again, I don't put this up to impress, but just to show the breadth of my experience and knowledge. This information also you can find on my website. There is a media page if you want to watch any of my past interviews and see the topics and stations that I've covered. So let's first go into what you're going to need to know. And it's kind of broad, but we are talking about emergency custody issues, custody being one of the most important and significant issues that we deal with men and fathers. So, and having to act in an emergency situation is very crucial, that you know what to do when that issue arises. So the first thing that I always recommend is that you retain an attorney, one who concentrates in family law. General practicing attorneys, not that I have anything against them. In many instances, they're actually very good and helpful. They fit a certain need and a certain client. But I believe when you're talking about emergency custody, as we will get to in a moment as far as what is required, you want to make sure that you get somebody who's knowledgeable, that knows the ins and outs of the law, the courts, and the judges that you're going to encounter, so that you can handle it correctly, and as the slide in front of you indicates, take immediate and substantial amounts of action. it's often very challenging to take an emergency custody case and have to drop everything you're working on to serve the client if you're not accustomed to handling these matters routinely. Oh, that just disappeared. So now let's let's next turn to the standard for an emergency custody hearing, because it's not the same as a standard motion or court application. So the first thing that you're going to need to know is the case that defines an immediate court action. It is not family based or limited. The Crow versus De Goya factors that you see speak of the standard for the court to give an immediate relief to a litigant in all circumstances, whether it's family or not. Here, the standard of immediate irreparable harm must be to the child at issue, obviously, as opposed to the parent or the economics. And we'll get a little more deeply into that as we, oh, I'm sorry, I didn't get the slide up. I think it's slide off. Harm to the child. So let's talk about what are some examples for granting or obtaining an emergency hearing. And these are not going to be exhaustive, but they're the most common. The first is obviously the removal of your child from the state. And that can be, even if it's 5 miles, you know, those of us who live in North Jersey are right outside of New York. Those in South Jersey are right outside of Pennsylvania. It's sometimes, you know, a hop and a skip, but nonetheless, the statutes specifically say you cannot remove a child from the state without the other parent's consent or court order if custody has or is at issue. And that's an important distinction. I'm going to digress for a moment. When custody is or has been an issue, means you've been to court in the past for some other reason. Child support, parenting time, divorce, maybe domestic violence. But there has been an order in the past. If there's not been an order regarding the child, whether it's custody, parenting time, child support, domestic violence, or anything, then it's technically not unlawful to remove a child from the state. Now, that does not mean that you cannot file the applications that we're talking about if your child's going to be removed and you haven't been to court. I'm just saying it's not unlawful. It's still emergent, which is a very important distinction. If somebody says they're taking your child out of state and they may or may not be coming back, it's obviously emergent, whether you've been to court or not. So just understand the distinction, but don't feel limited by it. I hope that's clear. If not, send me a message in the chat or in an email, which I believe I'll give to you at the end if you don't already have it. But it's Brad, B-R-A-D, at micklinlawgroup.com. That's MICKLINLAWGROUP.com. All right, so removal from state, probably the most common emergent application that we will encounter when discussing custody. Next is drug or alcohol abuse. Obviously, no, not obviously, but routinely we mean of the parent, but it can also mean of the child. It's just not as common. But if you have reason to believe that the other parent or whomever has custody of this child, of your child, is or has been using drugs or alcohol or has an issue, that can be grounds for an emergent application. And it doesn't necessarily mean, it's listed here as abuse, but that doesn't mean that they're like a chronic alcoholic or a drug addict. The fact that they may be just using alcohol around your child or when they have custody can be grounds for an emergent application if there's a risk of potential harm to your child. Neglect or abuse of a child, very broad standard, something that we'll talk about a little later into this webinar about DCP&P, Division of Child Permanent Placement or Placement and Permanency. But if you believe that somebody, and it doesn't necessarily have to be the other custodial parent, is neglecting or abusing your child, sufficient grounds to file an emergent application for court. And I guess one thing, I'm not sure if we touch on this, but we're talking about emergent applications, meaning you're going into court immediately and asking for immediate help, as opposed to filing a routine motion, which will be heard in a month or two in most cases. Just in case we're not clear. I imagine most of you are clear because you wouldn't be here listening to this emergency custody if you didn't have emergency custody issues. removal of the child from school or failure to place the child in school. Home schooling is often an area of conflict. If you have a child that is simply not going to school or not required to go attend school by the other parent and may be falling behind, also grounds to seek immediate applications to the court, because it's something that left unattended can grow to be a very severe issue. Exposure to inappropriate individuals, again, very broad, but this is because it's your child, and we're going to put to you to decide if you think that this is the case. If there's somebody that is or is doing something that's inappropriate or dangerous to your child, then you should seek to file an emergent application to get the court intervention, as opposed to waiting with the hopes that it improves or the person's behavior stops or is eliminated. All right, so now let's talk about things that may usually not be likely for the granting of an emergent application. And again, I want to digress because, well, let's stay going. So things that are not usually going to be granted. And again, it doesn't mean that they can't. It doesn't mean that you shouldn't consider trying it. And if you don't want to do it in emergent, it does not mean you shouldn't file for standard relief or a motion practice relief. But this is just when we're talking about what the courts are likely to consider emergent. Withholding vacation time, absent extraordinary or unusual circumstances, meaning they just said, oh, you know, you're not getting your child this week, or you're not getting the child for Christmas. Although I have seen, I got to admit, Christmas being handled by emergent application. I personally don't think it should be as significant as I understand the holiday is, and absent any religious affiliation, it's considered very significant to children, even those that don't actually celebrate it from a religious standpoint, because of the memories and the stories and the sharing, the camaraderie with their friends and family. So courts have, in many cases, addressed a conflict with Christmas parenting time as emergent, but I personally don't really think it is, and I don't encourage you to use this mechanism because it can cause more problems, it can backfire, and you can end up spending your holiday, you know, in court or online in some way fighting over the time, and nobody gets the holiday. Another thing that is commonly not considered emergent, financial or child support issues. Again, absent extraordinary and unusual circumstances. And this is the hardest one for people to understand, and even for me to really understand. Intellectually, I get it because I've faced this issue for decades, but courts generally say financial issues are not emergent. But to those of us who all of a sudden aren't getting your child support or alimony, and that's the only form of income that you have, it's very urgent. And I've often argued to judges, let's take your paycheck away and see whether or not you think it's urgent. But nonetheless, generally speaking, they do not find child support or financial issues to be emergent. But remember, with this and the other, and all examples are exceptions, absent extraordinary and unusual circumstances, because there are many, countless, filed countless successful applications based on financial relief that were urgent because of some other circumstance in the situation that needed to be addressed. So along those lines, there are always exceptions to the rules, and this also says exceptions to the exceptions. Every judge is different. Every case is different. A lot of the attorney and the attorney's reputation plays a part. I had a case, I won't go into the details or the names for obvious reasons, but it was a case based solely on financial relief that was urgent to my client because money was likely to disappear. But generally speaking, courts figure that that's not urgent because you can usually find money and return it. But the court granted the relief, which I was seeking was severe, and I think largely because of our firm's reputation that we don't just run into court and say it's emergent because our clients want to, but we truly do make sure our clients understand when it is and is not. So again, there are going to be exceptions to these rules and then exceptions to our exceptions. So don't just assume, especially if you're watching this and you have an issue that I say is not an example, don't just assume it's not and you can't go forward on it. Talk to a lawyer, or worse comes to worse, try it. It's better to try and be denied than to not try at all. You still always can file something afterwards in a routine standard matter, like a motion, if your order show cause is denied. But at least generally try it, especially if you're not with an attorney, because court's not going to be upset that you filed something that you should have known was not emergent. Whereas if we did, sometimes judges frown upon that. I don't know why these keep sorry that the slides seem to reverse themselves, so I don't want to duplicate. But so how do you weigh the pros and cons of DCP&P? As I mentioned before, Division of Child Permanency and Protection. This is the organization that's charged with protecting children. So the question always becomes, do we contact them or not? And I call it a double-edged sword, because first of all, my personal opinion, I don't believe any parent should be required to contact DCP&P for the protection of their child. I think every parent is and should be responsible for his or her own child's safety. And if you think there's a risk of harm to your child for some of the reasons we mentioned, then you should blaze into court and demand court's intervention. The reason I say it's a double-edged sword is judges will often ask you, did you contact DCP&P or first? And if your answer is no, a lot of judges will say, well, then you obviously didn't find it that important or that urgent, because that's what they're there for. They're there for emergent intervention, 24 hours a day, 365 days a year. So on average, my recommendation is to contact DCP&P first when there is an issue, albeit they can be very slow because they're high volume. And if they don't find anything urgent, that's another double-edged sword, because now you called DCP&P who didn't find it to be urgent. So the court's going to say, well, they went out and didn't find it to be urgent. Why are you bringing it to me? Going back to my original point, it's not up to anybody but you to decide if there's a risk of harm to your child. And just because a caseworker in DCP&P who might be real well-intended doesn't feel there is risk does not mean that there isn't, and does not mean that you shouldn't take other steps. Speaking of other steps, commonly people will seek the intervention of law enforcement, police officers. Now, technically, they have no authority to intervene and assist in any kind of custody matter. They can't enforce a court order, largely because they have no basis to know if the order is effective, if it was authentic, if it's been modified, because all they have is a piece of paper with some typewritten and a signature. For all they know, you typed it yourself. There's no central database. Absent a restraining order, there's no central database that has the records of these things. So police can't go and enforce a court order unless there's specific language in the court order to do so, and that's generally not going to be there. We'll talk about that later also. But contacting law enforcement can be helpful, first because they often act as if they have authority, and many people believe they have authority, so their actions do net a result, even though it shouldn't. If they can't, at least you have some witnesses to whatever's going on. They might, if you call them, they'll go out and do wellness checks, and they'll witness what's happening. They'll get statements. They may file reports. You too can file a report. And if you keep the names of the officers that you contacted or that responded, you'll have witnesses for future issues and court appearances if need be. So next, let's talk about things you need to do, like record keeping, when you're going to have now or in your future go into court for emergent issues. Because not every emergent issue happens. You get a phone call and the other parent says, I'm leaving New Jersey now. You'll get a message, hey, you're not going to see your daughter next Christmas. Hey, I got a new job in Florida. I'm moving next month. So anytime there's an issue, and this goes for anything. And as a side note, well, I tend to go in like a million different directions because I'm very passionate about these things, but I want to stay on point. So first, things you want to keep are important emails, text messages with the other person, or with the other parent, or other person if it's somebody other than a natural parent. This is important because you're going to need to prove not only what is happening, but the court's going to want to know if you tried to resolve it, how accurate and authentic you're being about the urgency, and ultimately what's happening. So always keep messages and text messages regarding custody matters, even if they're not urgent. And as an aside, where I was going a moment ago, I did a 2-part series on YouTube about how to use email tactically in family law litigation, because those that have custody problems, high conflict divorces, high conflict custody issues, will often have ongoing problems. So it's not just today, and it's not just one issue. And one issue that may be insignificant or less significant today becomes more significant as other issues pile up. And you want to be able to go back to having these messages, especially text messaging, because that's not only the more common way to communicate, but the more difficult to reproduce for a court. Again, as an aside to the aside, there is an application, I think it's called Decipher, that's really good for retrieving text messages, even ones that are deleted. Now, I don't know, because I've never used it myself. I've had clients use it. I don't know if you can enter a phone number that you have access to, like a family account, and it can retrieve messages from somebody else. Like, let's say you're the other parent and you share an account, you have access to the phone line. I don't know if you can retrieve those text messages or if Decipher is limited solely to your text messages, but that's good. That's usually good enough, because yours will include his or hers also. And it's usually the extent that you need it. And it puts it in a good form that's legible. And you can get a free trial, I think, for like a week, which if you only need this the one time, it's all you would need. But, and if you have a high conflict case, if you think you're going to have years of issues, you probably want to just get a membership and keep it. Turning back to record keeping, when you have custody issues that are likely to turn into emergent issues, you want to keep any kind of photographs, pictures, whether you take them on your phone or other people's phones, get Facebook, social media, get and save all these pictures and videos, again, in a place where you can retrieve them and possibly upload or email them, which is, again, things I cover in my email tactical videos on YouTube. Another thing you can consider is hiring a private investigator. This is going to be when, first of all, obviously have some resources, because they can be expensive. And it's a serious issue, and there's going to be some time between its beginning and the time you feel you need to go to court. It also may help just answer the question for you of whether or not there is something urgent, like, is there a paramour living in the house? Is the other parent bringing people that the courts have already said should not be there? A lot of reasons a private investigator can be helpful. It also removes you directly from involvement in the conduct that a private investigator would be performing, like surveillance, photographs. If you're surveilling the other parent and taking photographs and sitting out front of his or her house, you're treading into domestic violence areas. Private investigators don't have those same concerns. So in many cases, having them helps a great deal, because it removes you from that type of exposure. Keep notes and important timelines. If you write down in a journal or on a Google Calendar things that happened that day or on a day, or things that were said, that is admissible. If you've recorded it at the time that it was happening and it was fresh in your mind, that can be admitted. It's also just helpful for you and possibly your attorney to be able to recreate what was happening over the short history that led to this emergent application. So you want to have as much as you can. And with today's technology, like I said, Google Calendar is accessible to most of us. Emails accessible to, sorry. I think I was just moving forward. So now, as far as record keeping, as I was talking about briefly with the private investigator, continue, avoid inappropriate conduct or behavior that you don't want to explain to a judge. Like, first I was saying, as far as surveillance and photographs, but be very careful when you're recording conversations or leaving messages. A lot of people will leave inappropriate messages. Maybe they had a drink or two and they're angry when these issues come up. Corporal punishment is technically not unlawful in New Jersey. What is unlawful is excessive corporal punishment, but you still have to be careful if you practice this. So when you're communicating this, be careful. But also, if you believe the other parent is the one that's also committing this, be careful how you document and use this. Along these lines, keep your composure and avoid outbursts. The biggest mistake people make is by losing their composure, especially with emails and text messages and voicemails. I can't tell you how many times somebody said something foolish and hurtful in a message just because they were angry. I tell everybody, write messages, leave voicemails as if a judge is going to see and listen to everything, because it's quite possible that a judge will. And you don't want to have to be explaining your inappropriate conduct when you're trying to address something about your child that's urgent. Now, record keeping. Moving on for other significant issues about documentation, we have to talk about recording another person. So New Jersey is considered a one-party state, one-party consent state, which means simply that you can record any conversation that you are a party to without the other person knowing or consenting, if that person is in New Jersey. Very important distinction. Any other interception or recording of a conversation could be unlawful on state and federal levels, so you don't want to do it. It's very helpful to do it when you do it properly, because it's great proof. It's the person verbal stating what was occurring at the moment it was happening. There's also an application, well, there's many applications that you can use to record and transcribe the conversations so that you can attach it to papers, because you don't always know if a judge is going to sit and watch a 30-minute video, or if they have the time, or, and then for appeal issues. So transcribing the conversation is helpful. Now, I use and recommend an app called Rev, R-E-V as in Victor. It's an iPhone app. It's a one-touch recording. It's in my opinion, a great app. It's very convenient. It can also be uploaded and transcribed for a reasonable fee. The one limitation for court to know is that the transcription is not certified. So you can run into a problem from admissibility standpoint. So we're getting a little further off topic. This is more of a trial issue. In order to admit it, sometimes you need it to be certified transcription. But since it's likely to be the other person speaking, you may not need that, because it's an admission and it's admissible because of that. But just know, if you are in New Jersey and recording somebody in New Jersey, you can do it, and you should do it, because you can always just discard the recording if it doesn't get anything fruitful. So what do you want to ask for when you're filing an emergent application? And let me put a caveat, because you may have to bifurcate or split the immediate issues from your long-term issues. So before we jump into the specifics of what to ask for, when you're getting an emergent application, you're not likely to get a significant response from the judge, meaning, if there's a risk of harm, they're not necessarily going to pick up and transfer custody and stop the other parent from visiting. That's a very severe relief. But you may get a quick hearing and not have to wait 30, 40, 60 days for it. That may be the only thing that you're truly asking for on the immediate basis, is a hearing, is an expedited hearing, for instance. But generally speaking, most of the time, if there's a emergent custody issue, the first thing you are going to be asking for is an immediate transfer of custody. Now, it's uncommon a court will grant that immediately upon an initial filing of an emergent application, where the other person probably doesn't even know that you filed it. But you ask for it anyway, because if you don't get it immediately, you at least hope to get it the next time you're back into court, which will also hopefully be quickly after the original date. Next, if drugs are an issue, you want to ask for drug testing. Hair follicle and nail is the best. It's easy to get. It's hard to fake. Urine tests are not very helpful, especially with certain drugs, and with alcohol, they don't last long. If alcohol is the issue, you can also ask for an 80-hour test, which obviously goes back for 80 hours because alcohol is hard to detect inside of that. But basically speaking, you want a hair follicle and nail for drug testing. For alcohol, you want an 80-hour test. Another thing you're commonly going to ask for is supervised parenting time, because there's some reason that this child is being abused or neglected, and despite hopefully your efforts in advance, you have been able to stop that, or the other parent hasn't been willing to address it. So you're going to, along with the immediate transfer of custody mentioned above, you want the other person to be supervised when they are back in touch with the child or children until the issue is resolved and your concerns are satisfied. If you're talking about travel issues, you want to ask for the passport to be turned over. There used to be a way to call. There was a department in Washington that allowed you to sort of flag your child's passport if there was ever going to be, if it was ever going to be used. So that way you could say sort of in advance, I have concerns that my child's going to be abducted by the other parent. I want the passport to be alerted so that I get notified. I don't know if that still exists. This was many years ago when I had to do this for a client, but certainly something to look into. But if there's a travel issue, a flight issue, the parent is from, let's say, another country or has family in another country, whatever the reason, you think there's an issue, a chance the child's going to be taken and not returned, ask for the passport. And then a lot of people in these cases will say, well, I don't want to do that to the mother of my child. It could be the father of my child. It could be the surrogate parent of my child, whomever. Just for ease purposes, I'm using gender role names. Forgive me if you don't fit into those categories. But so a lot of people say, I don't want to do that to the parent. I don't want to escalate the issues. I just want, but we have to be realistic. Some people do bad things, and you can't take that chance. I had one case where a client came to me. The other parent had taken the child to Germany, where the mother was from, and stayed for like a year. And they were supposed to stay for a couple months and then just stayed and said, we're not coming back. And my client, instead of taking immediate action, waited several months, hoping to resolve it. And for issues far too complicated for today's webinar, but if you have issues like this, you want to research things about the Hague Convention. But because of the delay, he lost a lot of the protections the law would have originally or initially provided for him, and he had a much greater difficulty getting his child back. It took a very long time, cost a lot of money, and the relationship was changed forever. So when in doubt, turn the passport over. You want to ask for make a parenting time. Quite often, you're going to be seeking emergent court intervention because of missed vacations, holidays, alienation, indoctrination, and just getting an order that says the parent won't do that anymore is not always going to make up for it. So you want to make up parenting time. And of course, you want to ask for sanctions. And here's a court rule that allows for it. There are countless things to ask for aside from what we just listed. And each case is going to have its own set of unique relief that you may need. Look to not only what you want to stop the harm, but also ask for what may eliminate or alleviate the damage that may have been done. Counseling, therapy, change of custody, but also things like legal fee reimbursement, paying for the custody or paying for the counselor, countless things. So think it through. As I say often, speak to a lawyer, even if it's just for a consultation to get some idea. Watch some videos. I have countless videos on my YouTube page about orders to show causes, the relief, and the powers of a court in these circumstances. So let's turn over to the more general standard of best interest when it comes to custody matters. When you are filing an emergency custody application, as I said in the beginning of the video, you are going to be arguing there's immediate and irreparable harm to the child. but ultimately every decision about a child turns on whether or not it's in the child's best interest. And that's a very broad standard with very little definition to it. There are a number of custody factors that we will briefly touch on that you need to consider when you are filing an emergent custody issue. But first, before we get into that, you need to know to provide your attorney, if you're using an attorney, with everything that you have, everything that we talked about, whether or not you think it's important. Let the attorney be the judge of whether or not the message should go in, whether or not the video is helpful, whether or not the Facebook post made a difference or not. Don't just assume it isn't important. Give them everything, and as soon as you possibly can. So turning to the best interest standard, now there's, I think, about 13 custody factors. And these are custody factors anytime the court has to make a custody decision, whether it's an initial custody decision for new parents going in, or in a divorce case, or an emergent application. They're always going to be the same custody factors. Now, not every emergent issue requires the court to look at every custody factor. So you need to look at these factors to see if they are relevant to your case, because if a judge is going to want to address them, you want to be prepared with answers to them. So the first is, sorry about that, ability to agree and communicate regarding the child. Usually that's problematic if you're in this kind of a circumstance and you're filing an emergent application that hopefully you've tried to communicate and it's been unsuccessful. Parents' unwillingness to accept custody, generally not a significant issue in an emergent application. It's one of the custody factors for custody decisions. If your emergent application will eventually be seeking the change of custody, this will be a factor that will later be discussed or discussed by the court, but not necessarily relevant to your immediate emergent filing. Interaction and relationship with the children, parents and other siblings. Again, you want to talk about the family situation, more or less long-term, history of domestic violence, safety of the child from either the parent of physical abuse, or safety of either parent from physical abuse by the other parent, or the safety of the child. Sorry, that's a little convoluted. Going back again to the history of domestic violence, but there may not be a documented history, and that doesn't need to be the case. There doesn't need to be a restraining order to have a history of domestic violence or to have safety issues from physical abuse. So don't feel limited by that, but understand that these are factors the court should be alerted to in your filing. Okay, moving on to additional preferences of the child when of sufficient age and capacity. That's, again, a little nebulous. In my experience, more often than not, judges don't speak to children. They often feel they don't have the background or the experience or education to know about child psychology. They know law and they know legal issues, but they don't know much more than we do about child psychology, other than what they glean from their practice. But there are judges and there are issues where they will meet with a child. A lot of times it's going to be what's called an in-camera interview, which means behind the chambers door, in private. Usually lawyers are not there, but it is usually recorded. More often than not, you can submit questions, and if the judge doesn't say, you should ask to submit questions or things to be brought to the child's attention. People will often ask also, at what age does a court tend to listen to a child? And to some extent, no, there's no age. I mean, I've had cases where I've had 18-year-old college students, and a judge says, you're not picking who you live with. It's too sophisticated a decision to make. Not going to put you in between your two parents. But that being said, in my experience, also around 13, 14, a child is at a sufficient age and maturity to be listened to. Now, rarely, if ever, does a judge rely on what a child says, but around those ages, they'll start to listen to him or her more often. Next is the needs of the child, education, emotional, medical, religion. All these are going to be important for both your emergent application as well as any final decision or custody hearing. Stability of the home environment offered. Again, if you're changing custody, you're uprooting a child, you want to make sure the court knows that the child will be safe, protected, and happy and healthy where he or she is going or where they are going. And that's going to be more important than it may seem, because the most common reason a judge will deny an application, an emergent application, or a change of custody application is fear of disrupting the child's status quo. It may be bad or maybe less than ideal, let's say, but many judges feel that taking a child out of a home that they know and a school that they know and a system and a schedule and putting them somewhere else sometimes may be just as harmful as what you're alleging is happening in the current home. So you want to make sure that the judge knows that the home environment and the schedule and the finances will all be stable. Quality and continuity of education, along the same lines, you want to make sure the court knows that the child's life is not going to be uprooted or affected that much, if at all. Fitness of the parents, that's not necessarily a factor courts will go into because they will generally assume both parents are fit. If you've co-parented and decide to have a child with somebody, that carries a presumption you thought they were fit to parent. Now, more often than not, you're coming in an emergent because there is an issue of fitness, especially if we're talking about like drug issues. I mean, circumstances change. I'm not saying don't address it. I'm saying address it when it's appropriate, when there really is a fitness issue. Don't go in just saying, mom or dad aren't sufficient to be parents. They shouldn't have time, or I don't like the way they spend time, or the babysitter they chose, so they shouldn't have parenting time. It's going to seem disingenuous and actually defeat your application before you get there. Proximity between homes. Again, this is important if you're sharing physical custody, not necessarily for an emergent issue, but something to consider if there is going to be shared parenting time during the emergent custody review. You want to make sure that it goes back to the continuity of education. If you're in a different school district or there's a long commute to get the child to school or to get the child to see the other parent, is just something that you need to consider. Moving on, as I said, there's a lot. I want to touch on them as quickly as possible, but not to undermine their significance. Just I don't want to tie you up and have you here for 6 hours on these kind of issues. So extent and quality of time spent with the child prior to the separation, not necessarily significant to the average emergent application. Again, more of a basic custody issue, unless your emergent application revolves around some kind of indoctrination or alienation or long absence. If the other parent is frustrating parenting time or pitting the child against you, trying to poison the child against you, then explaining what you did have in the past as well as what is being lost now is significant. Employment responsibilities can be important. It's going to be case by case, but you may need to explain that you do have the time available to parent if you're seeking removal of a child or an increase in your parenting time. You want to be able to show the court that you're not going to necessarily be dumping your child with a babysitter or in daycare, which isn't a bad thing. If that is the case, you want to at least explain that. You're not going to lose custody or lose an application because you need to use daycare. But you want to make sure, you want to try to avoid as much as you can. If you're taking custody of your child, you want to be able to spend as much time with the child as possible. But nonetheless, either way, you want to explain to the court what is your employment responsibility, how will that impact the parenting and custody issues that you're asking the court to decide. Age and number of the children, for obvious reasons. The more children, the more complicated. The older, well, I was going to say the older, the more complicated, but that's hard to say. I mean, obviously, anybody who has a teenager would agree with me, but sometimes having a 2-year-old is more difficult because of archaic beliefs that they shouldn't be away from their mother, and then there's breastfeeding issues that often come up. But nonetheless, these are the 13 custody actions or custody factors. They are all significant. I don't want to seem like I was undermining any, but some are going to be more important for the emergent application, and depending on what your issue that brought you to the emergent application. And some are going to be more important for the subsequent return. And what I didn't get to touch on, I thought I would get to it, but I didn't. When you file an emergent application, you're going to have usually 2 stages to it. I touched on this when I talked about the relief. You're going to have the initial filing, and you want to ask for as much relief as you can, or at least emergent relief, like stopping parenting time or an expedited hearing. Then you're going to have the set of relief that you're going to ask the court to decide later. So the way it normally works is when you file an order to show cause, let's just move into the last section here. You file an order to show cause, the court will read it immediately, or should be reading it at least that day. That's what they're charged with. If they don't find an immediate irreparable harm or immediate, they could deny it entirely. They could convert it to a motion and schedule it in the future, or they could grant it and let you be heard that day or very soon thereafter. Now, if you are successful in getting an expedited return date, the last option, the court will take argument. The court at that hearing, again, may then deny the application entirely, schedule for motion, or give relief or schedule another hearing. So if you have a genuine emergent application, let's say it's drug abuse or parents fleeing the jurisdiction, something that you can be fairly confident the court will address on an emergent basis, you will get an expedited hearing. Hopefully it's that day or the next day, 2 days after that. And then you will get a second hearing by when the other parent has to be notified and has an opportunity to file papers and to be heard at length about the issue. So in short, there's 2 stages to an emergent filing. There's getting, and 2 things you want to get. You want to get an expedited hearing on anything that day or the next day, just to get the court's attention, get the court involved. And then you want to get a hearing in the very near future to discuss the issues at length. And that's very important when you review the part earlier about what to ask for, the relief to seek, because if you ask for everything at the initial hearing and the court can't grant it because it's not emergent, often they'll deny it because you're asking for something that's not emergent. So what I usually try to do tactically is file the emergent application saying, Judge, all I want is an expedited hearing. All I want is you to bring the other parent into court, whether it's virtual, by phone, or in 2 days, so we can make sure to address this issue before the harm is exacerbated or the child experiences greater risk. That's often a very good approach, especially if the relief you're seeking is questionable. Like if it's not so clear, Christmas parenting time, or I'm not getting my vacation time. The less you ask for, the more authentic the court will think you're being about the issue. If you go in and say, I got an email that I'm not going to get Christmas, so I want you to cut off parenting time and change custody, it's going to be denied flat out, because it's just patently unreasonable to take that severe of a position over an issue like Christmas holiday. So you want to balance what you're asking for at the initial request and the later request against the severity of the harm, so that the court will be more inclined to give you relief if it's not necessarily urgent, or if it could be deemed questionable how urgent it is. I hope that makes sense. If it didn't, post a question and I'll check them in a second to see if there's any questions to address. You can email me. I do my best to address emails. I can't always answer emails because there's potential conflicts of interest and it's hard to advise people without facts. But if there's something that's urgent and you need an answer, you can certainly try to email me. I always recommend people go to my YouTube page and my website. I have an abundance of materials I put up, like these webinars. I do some long, I do some short, and I've been doing them for years because I find most people don't even know what to ask me when they come to a consult or a webinar like this. So it's good to get as much information as possible, and then more pointed questions. You have more information, so the questions that you're seeking are more helpful to you and to the attorney that is trying to help you. We can only help what we can understand. So I hope this information helps you. If it does, please give a like and share it if you're watching this on social media so others get to see it. If you are seeing this on social media, I'd also appreciate if you would subscribe. It helps others get to see the video and also helps circulate it a lot for other people. I don't see any questions. So with that, I'm going to wish whomever is now listening the best of luck. Hopefully you never need this information, and hopefully your children are safe and protected. If they are unfortunately not, hopefully this information will help you make sure that they are in the future. Best of luck. Stay safe.